Hi, everyone. This is Mallory Flowers on behalf of Jennifer Shelton Associates, and we are coming to you live from Washington, D.C., and welcome to our Webinar Wednesday series. We are hosting a full day of complimentary webinars every 30 minutes until 4:30 p.m. Eastern, and our speakers range from accountants to attorneys and other industry professionals. The full schedule is on our website underneath the webinar tab. In the interest of time, we do not take questions, and our speaker's contact info is posted on the last slide. So if you have any questions, please contact the speaker directly. The recordings are on our website underneath the archived webinar tab, as well as on our YouTube channel. And this is just a quick blurb about us. Jennifer Shelton and Associates is based in downtown Washington, D.C., and we help both product and service companies with federal contracting. Our services range from market analysis work to contract vehicles, including the GSA schedule. We can also help you with proposal writing and post-award contract administration. More information about our services can be found on our website. And these are a few upcoming classes in January. More information can be found on our website or on these links. And we are now offering advertising in our weekly newsletter and in our 2019 Webinar Wednesday series. Please contact me for more information. All right, so we're going to go ahead and dig into today's presentation, which is Cost-Benefit Analysis of Bid Protest, and Mary Beth Bosco is going to be our speaker today. Mary Beth, I'm going to go ahead and hand over to you.
Okay, great. I guess if you could advance the slides, Mallory, up to the beginning. And let me know when you get there, because I am having some technical difficulties on my end all of a sudden. We decided that my internet just went out, so I'll have to do this from memory, but we should be able to do that without any problem. So today's webinar is on the bid protest considerations and strategies. We are going to go over and talk about the very quick review of the bid protest process. And then after that, we'll talk a little bit about the difference in the different forums. And then we will talk about what are some of the strategic things that you need to think about. And if you can bear with me 1 minute. All right. So, Mallory, can you adjust or open to the next slide, which is the one after the introduction? So, to quickly review bid protests, there are two types of protests. Pre-award, which is when you are protesting the solicitation terms itself. So, for example, if you have an issue with unduly restrictive solicitation provisions, ambiguity, or a sole source determination, these are primarily legal issues. They're not particularly fact-intensive protests. The second type of protest is post-award, and this is where the award has been made, and if you're protesting, you are a disappointed bidder. If you're the awardee, more times than not, you are going to be intervening. So these are much more fact-intensive protests, because you're often arguing that the agency unreasonably evaluated your proposal or treated you unequally. Can you advance the next slide, Mallory? So you've got these two types of protests, and you have three types of protest venues. You can protest to the agency itself, to the GAO or General Accountability Office, or the Court of Federal Claims. Next slide, please. And up on the screen now, we've got just a quick review of the differences between the three types of protest. So if you start at an agency level protest, if you file it on time, you will get the automatic stay. That is, unless the agency makes a determination of urgent and compelling circumstances, it cannot award the contract if it's a pre-award protest, and it can't proceed with the contract if it's a post-award protest. And that is really one of the most important considerations in thinking about protesting. Are you going to get the automatic stay? Because if the contract that was awarded keeps performing, at the end of the day, you may not be able to get any meaningful relief because the government will have been too far into the contract. Now, in an agency level protest, you don't have access to documents. There's no back and forth. Basically, you send in your protest to the agency, and then the agency has 35 days, although they often take longer, to issue you a decision. So that's it. It's a letter and a decision. It is by far the least expensive protest route, and we'll talk later about, benefits and the limitations of the agency level protest. The next level up is your GAO protest. Again, you get the automatic stay if you timely file. But in this case, there is some back and forth and exchange. After you file your protest, the government has 30 days to file what's called an agency report, which will include all the documents that the agency believes are relevant to the protest. You have a chance to ask for specific documents, and you have a chance to object if documents are being withheld. You will get a chance to, write your own brief and respond, and sometimes the GAO will ask for additional briefing and, in very rare circumstances, a hearing. That's when it's a very fact-intensive, technically complex protest. You might get a hearing. It's 100 business days for a decision. So you're talking about 3 months from the beginning of the protest. But again, the contract will be stayed during that time. The third and the most expensive route is the protest to the Court of Federal Claims. There you don't get an automatic stay. You actually have to move the court to grant either a preliminary injunction or a temporary restraining order. So, right there with drafting those papers, that's where part of the cost goes up at the Court of Federal Claims, or COFC. Definitely get access to documents similar to a GAO protest. The agency files a record, the parties then brief the record. There is sometimes a hearing, but it is in the nature of an oral argument as opposed to calling witnesses. And it is, as we say, the most expensive of the protest routes. Next slide, please. The other thing to think about as you are filing a protest or deciding to file or not file is, what are the range of outcomes? And am I going to be able to get relief that helps me? So if you're filing a pre-award protest and you're saying that the solicitation is defective in some way, the agency may terminate the solicitation. It may rewrite the solicitation and reissue it, but in some cases, it may actually just pull back the requirement entirely. So you want to think about whether that's a result that you would like to see. In terms of post-award protest, if the GAO or the court or even the agency decides that the award was made improperly, they have a range of options. They can simply reopen discussions with the folks who are in the competitive range, or they can just reevaluate the proposals without any further discussions, or they can actually take the contract back and recompete it. So again, as you're thinking about whether or not to file a protest, one of the things to think about is, is this the kind of case where I could win the battle but lose the war? If I file this protest and I get the award overturned, are they just going to redo the evaluation and still give it to somebody else? So that's a call you're going to have to make when you think about whether or not to bring a post-award protest. Next slide. So now to talk about the various protest levels and what you think about while you're deciding. The first is again, the agency protest. So what are the advantages of an agency protest? It's the least expensive means to obtain the automatic stay. You get it if you're timely. You can ask for a review by an official above the contracting officer. But again, the decision is going to be made by somebody within the agency. So the chances of it being a favorable outcome are usually not terrific. It is viewed as a less aggressive form of protest. So if you are worried about your relationship with the agency, it might be worth thinking about going this route. In my experience, the time to file an agency protest is really in a pre-award context, where there is something that is very obviously wrong in the solicitation, but you have not been able to get the agency's attention to correct it. So if there's an ambiguity, or if they, are so restrictive that there can't be any justification for this restrictive specification, then that's a time to think about filing an agency protest. Next slide, please. GAO is by far the most prevalent place where protests are filed. Again, the advantage is that you get the automatic stay. Another advantage is that you get an independent review, because the decision will be made by a GAO attorney rather than somebody within the agency. You can get documents, which is unlike in an agency protest context, and you can go to GAO within certain time periods and complain about the documents. You didn't get certain documents, or the agency redacted them improperly. And you'll get, again, a hearing before an independent person, your GAO counsel. It is, more burdensome on the agency customer than the agency protest, because the agency customer has to prepare this report and pull all the documents. So it's, sometimes viewed as, a little bit more aggressive, and depending on the agency, that may be a problem. Most agencies sort of view protests as just normal business. And in fact, particularly, agencies like DOD, they actually build protests into their scheduling. They understand that they're going to receive a protest. So the concern that it's going to anger the customer, I think, is not always a real concern, particularly, I think, if you're dealing with a more sophisticated agency like the Department of Defense. You get this decision within 100 business days of filing, and that's a pretty quick decision in the world of litigation. But again, the timing almost doesn't matter, because you should have an automatic stay, and the status quo will remain while the protest is being decided. In certain instances, you can recover your protest costs. For example, one of the outcomes of the GAO protest is corrective action. That the agency has takes some corrective action, but in cases where it does not take the action until after the report has been done and the report has been done and you have already filed a protest, your agency report response, then you are going to, you spent all this money that really wasn't necessary because the agency took corrective action, and therefore you have been allowed to recover costs, because the costs were almost, I don't want to say punitive, but you had to do a lot of work to get there. The other thing to think about in terms of an agency protest, a GAO protest, is that the awardee can intervene. So expect that. Why file at the Court of Federal Claims? You are before a judge. One of the things that I think is also good is that you are you get a Department of Justice attorney to come in and do a review. They actually represent the agency, and they, they really do give an independent review. If you could advance to the next slide, Mallory, that would be great. Again, like GAO, there's an administrative record, so you're typically not able to call witnesses, but the court's going to have more enforcement power and authority on procedural issues and document disputes than even GAO does. Again, we talked about this. You have to move for a temporary restraining order or a preliminary injunction, so you don't get that automatic stay. You have to sort of work for it. Again, the awardee can intervene. It is probably a more, how do I say this, open forum to more, let's say, novel arguments. That's one way it's viewed. So that may be a reason to file at the Court of Federal Claims. Next slide, please. So what other considerations? After you've decided, A, that you're going to file a protest, and B, where you're going to file, let's think about other considerations. The first, obviously, is how strong is your case? When you're challenging the agency's judgment, in other words, when you're saying something like, the agency erred in the way it evaluated my proposal, that is a very difficult protest to maintain, because, the GAO and the courts are reluctant to second guess agencies on technical decisions. This is particularly true when you're talking about something that touches national security. GAO and the courts are very reluctant to overturn agencies in that case. Where you have a strong protest is where you can make a case that the agency, say, did not follow the evaluation criteria set forth in the solicitation, or has a legal violation of the FAR. Those are the kinds of protests that have a much better chance of prevailing. Another consideration is, are you the incumbent contractor? There is a strategy that says if you're the incumbent and you lose the competition, you should file a protest, because if you get the automatic stay, you may get extra months of performance as the incumbent. Obviously, that's very disfavored by the agencies. This is a time when you can piss the agency off, because you, particularly if you have filed a weak proposal and the agency doesn't think you have any ground at all to stand on in protesting, and they think the only reason you're doing it is to get a few more months of performance. So whether or not you're the incumbent comes in. In terms of, do you want to, burn your bridges with an agency? As I said, a professional type agency or sophisticated agency should not view you in a bad light because you filed a protest. But you might want to think about, just in case, are you bidding on other contracts at that agency? One of the things we tell our clients, and that we do, is we'll say, okay, let's file a GAO. We've got grounds, but let's file a GAO. And then once we get the agency report, while we can't tell you the specifics because it's a protective order, we can give you our best judgment as to whether or not to proceed with the protest. And in some instances, you will learn brand new facts when you see the agency record, and we'll go back to our clients and say, you know what, we don't think we should continue this protest. It's just going to be throwing good money after bad money. So that's one strategy to think about. Overall, I think, Valerie, if you could advance the slides. Overall, I think that the protests are a very valuable means of A, keeping the agencies on a straight and narrow path. B, just sometimes finding out, what could have made your proposal better. In some ways you can do that, or maybe that how better to read a solicitation when it comes out. They're instructive in terms of what you should look at when you look at a proposal, and how you can help yourself in protesting the terms of the solicitation if you think it's unduly restrictive or in other ways prevents you from competing on a fair and open sort of field. And with that, I think my time is up. And thank you to Mallory, and thank you for listening.
Yeah, thank you, Mary Beth, and thank you for everybody who joined us. If you have any questions, please contact her directly with the information you see on your screen. And that's it. Thank you, everybody.